shortly. The proceeding will start 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 shortly.
Good morning, everyone, and welcome to the Justice and Home Affairs Select Committee in the House of Lords, and welcome particularly to Dominic Raab, Deputy Prime Minister, Lord Chancellor, Secretary of State for Justice. For our purposes, I think Lord Chancellor and Secretary of State for Justice, because we have questions about you and your department, obviously. But thank you very much for coming, Lord Chancellor. We've a number of questions. You've had notice of the headline questions, as it were, so perhaps we can just dive straight in.
Very happy to, Chair, and great pleasure to be here in front of your committee.
Thank you for coming. Obviously, you can't talk about the budget, so this is not a financially focused question. We know that other departments' policies impact on the MOJ, so we wondered what your ambitions are for your own department.
Thank you. Well, again, a great pleasure to be here before your committee, Chair. If I was going to summarise them, and I think it has to reflect the need for long-term strategic planning, but also the fact that we are now within 2 years of election. So I want to be realistic about delivery. I think Bill of Rights, the agenda on victims, we have pledged to introduce a victims bill, but there's also a huge amount of other work we're doing. We've quadrupled funding for victims since 2010. Parole Board, we've consulted on a root and branch review. I'm also committed to bringing in legislation very shortly in relation to that. SLAPs and strengthening, both as part of the Bill of Rights, but also more generally, the culture of free speech in the UK. Those are some of them, which particularly on the legislative side. More generally, there is clearly issues around COVID recovery, most obviously in the courts, in the Crown Courts. Related, but frankly we'd be doing this in any event, is the work we're doing on RASO, rape and serious sexual offences. We have a task force which I chair. That's a good example of the Justice Secretary and DPM role helping institutionally, because we have effectively, I bring forward the Home Office, the Justice Ministers, the law officers, the DPP, and it's a safe space based on our dashboards of data on rape, which we now publish, as well as the ones on general crime, which are localised to look at every stage of the process, police, CPS, court stage, and drive up our output as appropriately as we can, given the operational independence. And I would just note that in the last year, we've seen the convictions, the volume of convictions, increase by 2/3. Clearly issues around legal aid and our response to Lord Bellamy's review, and making sure that we have a sustainable basis for practitioners, and prison, both capacity and our agenda to create 20,000 extra prison places, but also the prisons white paper, which we're now implementing from everything to getting more offenders into work, which we've increased the volume or the proportion of offenders getting into work within 6 months by 2/3 in 1 year alone, right the way through to drug rehabilitation and the expansion I'm doing to drug recovery wings. So that gives you a sense of the priorities over the next 2 years in particular, where we're very focused on delivery.
Yeah. We all understand that, looked at from one point of view, that period of time is because it's the opportunity for delivery. It's also the run-up to the election, so there are different forces at work there. You used the word strategic. Then what I heard was the other word you used, which is agenda. I would imagine that anybody coming into the post of Lord Chancellor would think, this is my opportunity to do something I'm really passionate about, rather than be driven by outside forces. Is that possible in the position that you are in, or is it a question of being driven by events?
I think it's an interesting question as a Secretary of State, and you've got a number who have performed that role on your committee. Inevitably, there's an element of what you do, depending on whether it's the Home Office, the Foreign Office, or the Ministry of Justice, where you're responding. There's an element of that. But I think the priorities that I've set out show you the proactive, strategic agenda that we want to drive forward. Some of them inevitably respond to COVID. The backlog in the Crown Court is clearly are being pushed up by COVID and then subsequently the CBA strike. So some of them will be responsive, but I think most of them strategically are about what are the key things we need to deliver for the best interests of the British people. And I think if you look at the justice system, reassuring the public that they can have confidence in the justice system, I think that's particularly important for the violence against women and girls agenda. And secondly, the wider victims agenda, the people that most use or come into contact with the justice system, for whom I think it's fair to say, notwithstanding the professionalism of all the arms of the justice system, from police to the courts and the self-critique that we perform, but I think for a lot of people using the justice system, it feels a very difficult process. I've met with countless victims, from Denise Fergus, the mother of Jamie Bulger, through to the adoptive parents of Tony Hudgell, and Lizzie Harper, whose husband, PC Harper, was killed in appalling circumstances. And I think one of the things that you glean when you do that, and I think it's important to do it, is just to try and close down the distance that victims and those who come into direct contact with the justice system feel there is between what they feel heart and soul and what the justice system is delivering. So I think that's important too.
Thank you. Well, some of the issues we'll come back to, but I'm going to turn now to Lord Filkin. Jeff.
Thank you. Good morning, Lord Chancellor. On the 21st of February this year, you told the House of Commons that the government would not rule out withdrawing from the European Convention of Human Rights. As you know, Part 3 of the UK-EU Trade and Cooperation Agreement contained provisions for cooperation on law enforcement and criminal justice, and that these can be terminated immediately if there is a significant breach by the UK of ECHR. I'm sure you've been advised by your officials of the consequences of such a unilateral action by the ECHR decision makers. Could you tell us what you see as the consequences were that to occur?
Yes, no, and thank you. And of course, I'm very mindful of the TCA. The position of the government is that, and you can see it in our Bill of Rights, not only are we committed to remaining a state party, but also we've retained certainly one element of the HRA model, which is to incorporate the convention schedule, and that's important. So I don't think that there is any risk in the short to medium term, and indeed we've reaffirmed our commitment to the ECHR. It is true that we cannot rule out forever and a day the possibility that we might need to revisit our membership. But there are lots of steps that would need to be taken before then. And of course, I was in Strasbourg recently and I spoke to everyone from the senior members of the Judiciary to the Secretary General. And we made clear we wanted a positive relationship. We wanted to engage in the dialogue, which is what we're entitled to do, and to avail ourselves of the margin of appreciation. There are issues, I think, in relation to illegal immigration, interim measures. We want to talk those through. That's why I went. That wasn't just a one-off meeting. I'll continue to do it. I've engaged with them very constructively before, for example, over prisoner voting. So I don't think it is likely, but we can't rule it out. And I do think the one thing, we can't rule it out for all eternity. I think folk know that I believe that we should strive every sinew to remain in the ECHR, and there are various reasons for that. But I think on something like illegal immigration, the case law of the Strasbourg court has ebbed and flowed over the years. And if you think of the period during the 90s and the noughties, I think there was a huge amount of emphasis on the living instrument document. I think in fairness, and I always want to be fair about this, under Judge and President Robert Sparno, there was more emphasis, and he talked extrajudicially about this, about the age of subsidiarity. So first of all, I would say, I think you could say this fairly about the Supreme Court and the Strasbourg Court, that some of the more expansive judicial interpretation has ebbed in recent years. But what ebbs may flow, and it is important, I think, to curtail within the proper bounds of the separation of powers how much judicial legislation there is at domestic level and at the international level. I think this is a proper subject for dialogue between the UK and Strasbourg, and we want to do so constructively. So I understand the question you asked, but we're not remotely in that territory.
Maybe I could come back in a second to the chances of a breach, which you've characterised as very low. But before doing so, can we just clarify what the risks would be where we, for one reason or another, to exit ECHR? Just to give you an illustration of what's in the committee's head, we received evidence yesterday from National Crime Agency and police services about how the system by and large is recovering after exiting. We've built systems in place for the exchange of information which allows it to be workable, if not perfect. I'm putting it very simply. But they pointed out also that we, for example, in 2019-2020, we extradited 285 individuals. There were about 4,500 offenders that we wanted information from the EU in the form of fingerprints, criminal records, other forms of data that are pretty essential to the pursuit of law enforcement and criminal justice, because as you know better than we do, most criminality is international in this nature at present. And so such systems are pretty fundamental. All of this would be lost, not least the ability to extradite serious criminals and terrorists from the EU were we to leave ECHR. That is the case, is it not?
So thank you. So first of all, even if, and I don't foresee it for a second, there was a breach of the TCA, there would be a whole range of negotiation before you'd end up anywhere near the consequences you've talked about. So I don't quite jump to those consequences because your original question was about risk. Secondly, in terms of context, exiting the EU has given us control back over our immigration policy and our borders, and therefore for the purposes of immigration control and deportation, there is a major, major advantage. Thirdly, now to hone in on the point you made, I certainly accept that there are some things that we would like to do with our EU partners in the JHA field that rely on the TCA, for sure. And I'm glad to hear you say that in relation to the current relationship, although it may not be perfect, actually we've maintained quite a lot of the law enforcement cooperation, because if I'd have been sitting in a committee like this before we'd negotiated our exit, the doomsday scenarios on what would happen to law enforcement were frankly have not materialised and I think fairly the way that you have now set out. We actually have a good working relationship. We want to keep it. It may not be perfect. There may be more that we can do, but we do want to keep it. So I think overall we're in the right place, and I think we'd need a very good reason to want to jeopardise that. But of course, as ever, this isn't just about what the UK does. It is about, firstly, what does the Strasbourg Court do, which is why I referred to the age of subsidiarity. If they continue along that line, if we see the right measure of marginal appreciation, I don't think the risks you talk about will materialise. And secondly, the relationship we have with the EU, I think is in a much stronger place, both because of the TCA, but also things like resolving the Northern Ireland Protocol through the Windsor framework. I think you can see over the last week the bilateral relationship with France is clearly in a stronger place. So I would feel a bit more upbeat, but I'm certainly not dismissing, and you've registered the points well, that there is value in law enforcement cooperation, and where it adds value, whether because the NCA or otherwise make that case, we should try and preserve it.
Thank you.
Jeff, just before you come back, and I don't want to stop you, but I need to remind all the committee and myself, because I went on quite a bit, we've got a lot of questions to get through. Well, it's an important topic.
Two last ones, which are on the issue. The first question is the level of risk. You said there was little or no chance that we'd leave ECHR. I'm going from memory, but I thought that Suella Braverman had said there was at least a 50% chance that the Bill of Rights was non-compliant with ECHR. How do you square those two?
She didn't say that, and it isn't. Bill of Rights has been introduced, and I'm certain that either as... well, put it this way, the current Home Secretary was Attorney General when we produced the Bill of Rights, and you can see from the papers that were published when we did so that we feel confident that it is lawful.
You're right, it was the Attorney General that said it, wasn't it, rather than Suella Braverman?
So which Attorney General? Because Suella Braverman was, of course, previously Attorney General.
Whatever, from that office.
Whatever. Why don't you clarify the question, and then I will try and give you a more precise answer. But what I can tell you is that the Attorney General, who was Suella Braverman at the time, gave the Bill of Rights a clean bill of health, both as a matter of domestic and international law.
All right, let's leave that for now. You said on the 21st of February that you wouldn't rule out the withdrawal. On the 27th of February, the Prime Minister told the House of Commons the UK is and will remain a member of the ECHR. My question is not for you asking you to resolve those contradictory statements, but whether you agree that this confusion undermines the confidence of our judicial and law enforcement partners in the respect for law and in the consistency of the UK's position regarding ECHR.
With the greatest respect, you may be confused, but I don't think they are. The position is very clear. We are committed to staying within the ECHR, but we've said, if asked, we couldn't rule out forever and a day that we might have to revisit that position, but that would depend on the response of the Strasbourg Court to the vital issues that we are trying to pursue in this country, including stopping the small boats.
I see. Thank you.
That may be where you're thinking of the 50%.
Yes.
Lord McInnes.
Good morning, Lord Chancellor. You referred earlier to the importance of the announcement on the protection of women and girls from domestic violence the government made in February. An important element of that policy is electronic tagging and monitoring. So really two questions. First of all, I wondered what your personal opinion was on the efficacy of electronic monitoring and tagging in general. And secondly, what will you be looking for in the trials that are going to be carried out in terms of electronic tagging and monitoring in relation specifically to the protection of victims of domestic violence?
Thank you. And I'm on my fourth tour of duty in the Ministry of Justice, and tagging has come a long way. And Lord Blunkett will remember from his time some of the ups and downs in tagging. The big tech shift has been between RF tags and GPS tagging. RF tags, effectively, you could only really be told whether an offender had, for example, in relation to, say, a curfew, was not at home. The GPS tagging tells you where the individual is. And that's particularly important, for example, if you had a stalking offender or someone who had a track record of domestic abuse, because you know not just where they're not, but where they are, and are they breaching any conditions which may be geographically prescribed. So I think we've come a long way, and as the technology improves and the cost comes down, the ability to roll the EM tagging out with the GPS is very significant. We're this year going to be launching a project which will allow for EM at the point of release from custody of domestic abuse perpetrators, and for offenders where there's an intelligence risk that comes to light later post-sentence. Obviously, we want to incarcerate those who are dangerous for as long as possible, but within the bounds of what the sentence is passed down by the court. EM tagging in those areas offers us a significant extra tier of protection. And so I want to evaluate very carefully how that works in practice. You'll also be aware, and the committee will be aware, of the changes in the 21 Domestic Abuse Act and the Domestic Abuse Protection Order. We want to look at the measures that we've introduced there for domestic abuse and apply them in other areas like the family courts, the police being able to use a DAPO in the magistrates' courts. We'll pilot that from spring of 2024, and they'll be fully evaluated. And I would probably envisage a phased national rollout, but I don't want to prejudice the outcome of the pilots.
Thank you. We'll move to the parole system. Baroness Usha.
Thank you, Chair. Good morning, Lord Chancellor.
Morning.
Before asking my questions, I want to declare two interests. I was the Executive Chairman of the Parole Board from 1997 to 2001, which is now nearly a quarter of a century ago. And currently, I am the Vice Chair of the Penal Reform All-Party Parliamentary Group. My questions are about the parole system and the changes that you have introduced. In March last year, as you said earlier, you published root and branch review of the parole system, and subsequently in June, you introduced changes to the criteria for transfer to open conditions, including the power of ministers to be involved because you said you wanted closer ministerial oversight. What I'd like to hear from you, what do these changes actually mean in practice? What have been the consequences of these changes? And how have these changes impacted upon pre-tariff reviews? And of course, some have argued that the changes introduced by you are a risk to the public safety. So yes. I'd like your views on all those questions,
thank you,
please.
And thank you for your service. And the Parole Board and all of those acting in probation and related to it do an incredible job. I think systemically, my diagnosis is that parole has become adrift from its original moorings, which were strictly public protection. And at all times, my overriding priority is public protection. I think if you look for Luke's judgment and some of the case law since, and inevitably because of the Human Rights Act, a strict public protection test has become, if you like, stretched or redefined in order, first of all, that it is balancing with the interests of the offender, whether it's in rehabilitation or proportionality, and various other things. And therefore it is not, in the way that Parliament originally conceived it, a strict public protection test. And there are various reasons why the judiciary have gone in that direction, and I don't criticise them individually, but I do reflect on the direction of case law. What this means when you come down to the brass tacks of reviewing parole cases is that effectively you get about 4 or more professional reports. One will, for example, OASIS tends to look strictly at risk, and if you like, the bread and butter of what the public protection test should do. Then you look at things like a psychiatric assessment. You also look at the extent of engagement with offender rehabilitation programs, and then you look and get a separate report on ability to manage in the community with licence conditions. At every stage, except the first, my fear is that we've come away from the context of strict, factual, inquisitorial assessment of risk. And I want to return and re-anchor the parole system in that. The second thing I notice is that I think less than 1 in 20 parole board members has any law enforcement experience. Now, we need to recruit, and we are recruiting more former police officer or law enforcement folk to sit on parole board panels. And in relation to the most serious cases where threat to life or limb is in place, I think we need to mandate it. The reason I say that is because if you're a psychiatrist or you're working with a very grisly, someone who's committed a very grisly offence, particularly multiple murders or rape, getting them to engage at all with rehabilitation programs is often very difficult. And if you track their progress by millimetres, actually, rather than metres, if I can put it that way, you will notice positive steps. But actually, if you take a step back and look at the big picture, the individual is still an excruciatingly risky proposition, both in terms of the danger to the public, secondly, any sense of predicting what they may or may not do. I think that there needs to be a bit more humility around assessment of risk in relation to some of the most serious offenders. And so I would like, because my experience is that people who have worked in law enforcement or probation or probably on the wing of a prison, who have actually had to deal with the individuals we're talking about, people that are in a Cat A prison or have committed very serious, egregious offences. I think their view of risk will be slightly different from someone from the social science field who looks at it in terms of the baby steps of engagement that they've had. The final outcome of that, therefore, is that I want to take a more precautionary approach to risk, and I want to change the criteria in the public protection test to re-anchor it and be more prescriptive about risk. And I also believe that at Secretary of State level, in relation to those who are either the greatest risk to harm, to life or limb, and also the greatest risk in terms of likely serious further offending, ought to have a further tier of check at ministerial level. And I'm thinking of murderers, terrorists, rapists, and those who kill children unlawfully. And so everything we're doing is focused on risk. I'd be very happy to address any specific question. I understand the point you're making about actually transferring offenders into open conditions gives you a chance to test their level of risk before going into the community. The only time I've ever vetoed that is when I don't think that has been made out, and we're balancing that opportunity with the risk to the public or the risk of an abscond. I've taken a different view. I wanted to try and answer all the elements of your question, and I'm sorry if my answer was too long, but that's the approach that we're taking.
I have a couple of supplementaries to that. I understand that you balance the question of harm and risk and rehabilitation. But from what you say, it doesn't quite stack up against the evidence, because if you look at the record, I don't have the figures before me, of the parole board, I mean, its record is pretty good in terms of, if you look at reoffending and so on. And secondly, when you talk about the assessment of risk, in my experience, and I observed it carefully, the parole board members are multidisciplinary. You need different perspectives. And the changes that you've introduced seem to be not based on any consultation or any firm evidence. And also there is evidence out there that the transfer to open prisons has really declined, and that's having an impact on the prison population. And I think it would be very helpful for the committee to have some evidence of what the impact of these changes have been on the prison population, and how the numbers who are being moved, transferred to open prisons has actually declined quite a lot.
A really good question. So in terms of serious further offences, look, I'm not criticising the track record of the parole board so much as recognising, in the way I described, that it has become adrift from its original moorings. The track record in relation to serious further offences, I think, is generally fine. But if you look at murderers and rapists, and some of this arguably goes to sentencing, and I'm not criticising the judges, but sentencing policy, and therefore you could exponentially increase the prison sentences for some of the most dangerous offenders. But I'm not sure that would be the right answer either. But having a more robust parole decision-making process, I think, can help in relation to the worst serious further offences. And that's why, for example, if I look at the proposals that we've put forward for a ministerial check, it is only on those where our record with SFOs, I wouldn't say, I don't even argue that it's deteriorated. I would just argue that if you have a murderer or a rapist committing further offences, I think that is something which creates public confidence issues for the public. And if you look at where we've concentrated, it is those areas where that arises. I agree with what you say about multidisciplinary composition of the parole board, but that wasn't the point I made. My point is that we've squeezed out the raw law enforcement risk assessment people who can tell you and who know and understand risk. Why? Because, as Lord Blunkett, I'm sure will know, you get all sorts of bits of advice as a Secretary of State, but the police officers know what it's like to pursue a murderer, a rapist or a terrorist. They also are the ones that go and tell the bad news to the families. And therefore, having them, if you like, airbrushed out by degree, because as I gave you the figures, I think it's fewer than 1 in 20 parole board panel members has law enforcement experience, isn't getting range. In fact, we've lost range of disciplinary expertise. In terms of consultation, May I politely just disagree with you? We consulted on the legal branch review, and I'm finding a legislative vehicle for the parole reforms, and I would like to say something about that shortly, and so there'll be all of the proper scrutiny. And in terms of open conditions, you're right. If you look at the capacity in the closed prison estate, it's in the high 90 percentages. So you're looking at 98, 99%. And if you look at the open conditions, it's something like, forgive me, I may get this wrong, in which case we'll follow up, it's something like 85%. I definitely want to make greater use of the open prison estate, but I want to be very careful that I do it with those who pose a lesser risk and have got more chance of being rehabilitated in the community, and make sure that the closed estate is there for those with a higher risk. So I accept your last point in terms of diagnosis, but I think if you look at what we're now doing in practice, I think it's slightly behind the curve, if I may say so.
Can I just ask one more question? You rightly yourself said, that you're looking at the composition of the parole board. I mean, when I was there, there was a right mix. But if that's the case, why don't you change the composition of the membership of the parole board rather than give the Secretary of State greater powers? Because that would be contrary to the European Convention on Human Rights, because in a way they say that release should be determined by a court-like body. And how can you be involved both in the process and make the judgment?
So on that, I'd make 2 points. First of all, on composition, we are doing that. There's a recruitment campaign underway to recruit more law enforcement, people with law enforcement background. So I totally accept that, but that's what we're doing. Let me just gently say, I think the paradigm of the parole board as a quasi-judicial body rather than an inquisitorial body that is engaged in the fact-finding process of assessing risk is wrong. And whilst we will make sure that our approach and our reforms are legally compliant, I think if public protection is your number one and overriding priority, then actually it is an inquisitorial and fact-finding process in the way I described. And I don't think it is particularly helpful to regard it as a judicial or even a quasi-judicial body, whatever that means in practice. What I will always accept, though, is that you need to have checks and balances and the ability to question and challenge the detention beyond the tariff.
I'm afraid I have to challenge you on that, because risk assessment is always inquisitorial and court bodies can be inquisitorial, but I think we'll leave it at that.
But let's just test that, because I think you raise a good point. Judges conduct independent inquiries all the time, but there's a fundamental difference between a quasi-judicial process and an inquisitorial process. One is adversarial, which is where we've got this testing of risk versus interests of the offender. I don't think that is, in my view, paradigm that serves the interests of public protection the best, but an inquisitorial process, whoever the individual leading that process, whether it's a judge or a non-judge, I think is.
I agree with that, because risk assessment said is always inquisitorial, and that's what it was when I was there.
I think you did a fabulous job.
As a committee, we'll be coming back to this, I think, because there are different views as to what goes to create public protection best. Some of us remember the slogan, "Prison Works." But let's move on to IPP. Lord Blunkett, David.
I suppose I ought to declare an interest in the sense that I was the lead on the introduction of the Criminal Justice and Sentencing Act 2003. And 20 years ago, Lord Chancellor, we were weighing the issues that you've just been addressing in respect of risk. And we put in place, as you know, the imprisonment for public protection in the belief that there would be therapeutic courses, there would be measures taken within the prison service that would enable those who were released to be able to stay freely in the community without committing further crime. That part of the Act has clearly failed, and it's failed on a number of fronts. I could spend all morning, which I won't, Chair, on addressing, thank you, on addressing why. But I just wondered if we could just explore, when in responding to the Justice Select Committee in the Commons on the 7th of February, on behalf of the government, you rejected the idea of an independent expert panel, which, even if you were rejecting resentencing for those under this IPP sentence, might have actually helped to have addressed other parts of the possible solutions in reducing both the number who are still in prison, and it's around just over 1,400 who have never been released, and the 1,500 or so who are currently on licence with the constant danger of recall.
Thank you, Lord Blunkett. Did I detect a mea culpa in all of that?
Oh yes, it's very rare in politics you get the chance to try and do something to redeem something you got wrong.
Well, bless you for that candour. Look, let me try and address this as straightforwardly as possible. I think the IPP sentence was a mistake, and we have changed the law, and the question is what we do with those who have already been sentenced. I still believe that the action plan we've put forward is the best way forward, which is, in the way you described, trying to prepare those offenders subject to an IPP sentence to be able to pass the parole test, that they're no longer a risk to the public. And I don't agree with the proposal to resentence them, whether with a panel or otherwise. I think that would, on everything that we currently see, result in an unacceptable risk. And we come back to the kinds of considerations that I was discussing earlier. Following the JSC report, I asked the Chief Inspector of Probation to carry out an independent thematic inspection on the proportionality of recall to make sure that we get that right. I've also changed the policy so that offenders with 5 years continuous good behaviour in the community will automatically be considered to have their continued supervision reviewed. I suppose we're making progress, but not fast enough. Just so we are clear on the figures, we inherited over 6,000 IPP offenders in prison in 2012. The number of unreleased IPPs now stands at 1,394, so I think slightly below the figure that you gave.
Only 6, Lord Chancellor, so let's not nitpick.
Well, look, if we...
100.
No, look, I'm just giving you the accurate figures so we can have an informed debate on this. I want to get that number down. I recognise that this was a mistaken policy, but I want to do so in the right way, and as ever, I'm very focused on risk.
What is, I mean, I think we're all, those of us, and there's great cross-party agreement in the House of Lords on trying to do something drastic to put this right. And I think you have actually cross-party opposition support for whatever measures you take that ameliorate the situation, which is unusual and allows you some political leeway. We're all in favour of the refreshed action plan. What would be the role of the supervisory board that was mentioned in the response on the 7th of February? Is it going to have a longer-term role in trying to get this right?
Well, I'm open-minded. I'm not theological about any of this. I'm open-minded. What I want to try and do is just get those numbers down practically and safely and responsibly.
Without over-egging the issue this morning, forgive me, but could we just address very briefly those who are on licence, because this is a really big issue for those subject to the licence conditions and for their families. You mentioned the 5-year point. It used to be 4 years. It is true, isn't it, that if people are going to reoffend, it's usually under 2 years out from release, and that there is real concern about the nature of the recall to prison on breach, as opposed to breaches being dealt with in other ways, including more intensive supervision, or even, as we were discussing earlier this morning, the issue of tagging. Isn't it simply true that we put greater pressure on the already beleaguered prison system by recalling people who then return on the original IPP sentence, not sentenced on the actual breach that they've undertaken?
Well, there's some merit in that, but of course that's why they're subject to licence conditions. But I do want to look at the proportionality of recall in the way I described, and I do want to try and allow IPP offenders who've got 5 years of good behaviour in the community to be able to get a clean bill of health. But the truth is, with a lot of these offenders, and as a result of the sentencing by your government, if I can put it as bluntly as that, and the time that they've spent in prison, they are very complicated cases. And we've got the backlog down from 6,000 to 1,394. But there is a reason in the parole board's decision, and they operate independently of me, why they keep failing to get the approval to be released into the community. And what you're therefore asking me in relation to the proposal of resentencing is to brush that to one side, to put them in the community, and then to assume the risk to the public that involves. And I find that very difficult to do, and I think the right course of action is to try and prepare them as best they can to pass the parole board test that they're currently failing.
Just one final point. Yes, it was my government that introduced it, although there were prisoners on 2 strikes and you remain in who are still in prison from the 1990s. I'm dealing with one case of a man that was sentenced to 7 years, and it wasn't murder or rape, and has been in 33 years. So I don't think we need to concern ourselves with purity on political ideology. Perhaps you just address the issue that's been raised with me by forensic psychologists and psychiatrists who at the time, 20 years ago, thought there was a real case for the IPP, and now, like I do, realise that it was a mistake. Their point is that the longer these prisoners are in or are on licence, the more likely it is that rehabilitation will fail.
And that's exactly the snare that the policy has left for this government to try and deal with. It's exactly the snare. But I think the answer to your question in terms of psychologists, social scientists more generally, is I think we need to have more humility about the concept of risk. My job is to protect the public, and by the way, if you look at what we're doing on drug rehabilitation, getting offenders into work, giving them the skills they need, offender homelessness, and all of those rehabilitative elements, we are driving forward massive change, and I'm entirely convinced of the case for it. But in relation to IPP and some of these other cases, where the question of dangerousness arises, I think that the psychiatrists and the social scientists involved need to have more humility, not just in terms of our ability to forecast risk, but our methodology of looking at it in the round in a way that can deliver any precise results. I think it is, in the same way as economic forecasting has come under quite a lot of criticism, I think forecasting risk in some of these very complicated cases, and you're right, Lord Blunkett, particularly when that has been compounded by years in prison, is inherently difficult. But I'm afraid that is why, whether it's on this or parole, I take a precautionary approach.
I'm very grateful, Chair, to the Lord Chancellor, not least for being the first Conservative Lord Chancellor I've ever heard accuse the Labour government of being too tough.
Well,
it's not a question of being too tough. I don't think
no,
it's very...
all right, you had a go at me, I'm just having a
no,
go
sure.
back.
It's not about being too tough. It's about being smart.
There's a lot we could pursue there. We could spend the rest of the day talking about all this. But can I re-emphasise the point that Lord Blunkett made about the cross-party enthusiasm in the Lords for trying to get this right. Let's move to the, as somebody said, beleaguered prison system. Lord Sandhurst.
Lord Chancellor, I'd like to ask you about prisons overcrowding. In October, the House of Commons Library produced an overview of the prison statistics, population statistics. And these showed in respect of England and Wales, and I'm going to focus on England and Wales, obviously, that 52% of prison establishments were overcrowded in the sense that, using the jargon in the prisons population bulletin, it exceeded certified normal accommodation limits. The February bulletin, which I had a look at last night, shows the figures for February, showed that the excess, the current excess, is 6,966, which I calculated as 9%. Interestingly, the bulletin itself describes certified normal accommodation as the good, decent standard of accommodation, and talks about humane conditions. I've got two questions in that context. How is the Ministry of Justice working to ensure that such decent standards and health and safety for prisoners and indeed staff are maintained? That's the first question. And the second question is, how does penal policy and prison strategy and planning respond to the current excess and possibly increasing proportion of custodial sentences and their increasing length? Because if they're going up, this problem is going to be a problem for you.
Yes, well, thank you very much, and it's a really important issue. It's one of the things I'm spending a lot of time on. I do think there is some learning to be done, which this government is actively engaged on, in thinking about the system more holistically. I'm, again, 4 times in the Ministry of Justice, and encouraging joined-up process from the impact of what happens amongst police forces right the way through, not just what happens in prisons, but then on probation, subsequently, or on licence, I think is very important. And even in other less obvious ways, like the continuity of NHS provision on drug rehabilitation, making sure that you don't get a cliff edge of what the approach is in prisons compared to what is there in the community. I think the short answer to the challenges that you've described is that we are delivering and committed to delivering 20,000 more prison places that will provide not just the space, but the kinds of conditions and capacity and regime that will drive rehabilitation. If you look at 5 wells, I mean, it's extraordinary what you can do with in-cell technology so that offenders can not just sit there with their feet up on the bunks, but engage with counselling, with education, so that they are meaningfully engaged. If you look at the workshops at 5 wells, getting offenders working, again, deriving the skills they need, which is critical to going straight on the outside. I think that the quality, not just the quantity of prisons that we are now able to produce is a quantum leap forward. And we've delivered 3,100 of these prison places already. COVID has certainly not helped that, both in terms of inflation, but also what's happened to the supply chains. So we, of course, recognise all of that, and we're very focused on delivering as much as we can. So I think within all of that, we're waiting for the places to come on tap. We've made progress, but there's more to do. We continually monitor prison conditions. We look at it in terms of safety levels, but also maintenance. We have a cell certification process in prisons where they're over the threshold for crowding, and we've committed £37 million to make prisoners safer, both for staff but also for offenders as well. I think the big thing for me is prison clearly has a role in terms of incarceration and incapacitation of dangerous offenders. We've just spent a lot of time talking about that. But I also believe very heartily in a second chance society. And I think if you look what we're doing on drug addiction, there's too many people that effectively get dumped on methadone and languish on methadone. There's a theological battle that I hope we have now settled on the importance that methadone for opiate users, heroin or otherwise, is a short-term stabilisation phase before you get offenders abstinent. And if you look at the rollout of incentivised substance-free living units and then drug recovery wings, I think you can see what we're doing in relation to that. The progress we're making on getting offenders into work, increasing 2/3 of the proportion of offenders within work within 6 months of release. And again, some of the other things like the prisoner passport for resettlement, which looks at all the things that gives an offender a fighting chance of going straight and taking the second chance I described, from homelessness to drug rehabilitation provision. The thing that we're doing on giving governors the ability not to release on a Friday, those with experience around the committee will know that that is, it sounds like a small thing, but is a big thing in terms of avoiding an offender going straight back into old ways without access to the benefits and the other support they need. So I think the prison strategy has a capacity question, which you rightly raise, but also a regime question, which we are just as focused on. And Edward Timpson has done an extraordinary job working with us in getting employment advisory boards into prisons and making that work piece really effective, and there's more to do.
If I can follow up, that's very helpful. 20,000 more places. The current, what they call certified normal accommodation is just under 77,000. So let's call it a 25% increase in places. That requires also, presumably, at least a 25% increase in prison staff, I assume, if the manning is going to be proportionate. Or, a substantial increase in warders and governors and, no doubt, probation officers who come into the hospital. Have you got the budget for that? Or is it going to just come from other things?
No, and I can certainly write back to the committee with the budget. First to say, there's a lot of effusive things rightly said about all of our emergency service workers, from the NHS to carers and police officers, and rightly so. I have to say, in my experience, there is no finer public servant serving the UK today than the prison officers, who are doing a remarkable job, and I would add the probation officers to that. I mean, I've been from Cat C prisons to Cat A prisons like HMP Franklin, which are doing an astonishing job with a very difficult cohort, and they're obviously different depending on the prison. So I recognise and spend a lot of time thinking about how we can make their job, both financial and non-financial terms, as rewarding as possible. And I think the team at the MOJ, Phil Coppell, Amy Rees, do an extraordinary job. In terms of recruitment and retention, we have a plan for recruiting more officers, and at the last SR, and now I won't say anything about the current budget, but we delivered the biggest increase investment in the MOJ for a decade, and rightly that included provision for recruitment of more prison staff and probation staff, and the broader piece about retention and making that a profession that is recognised for the extraordinary job they do, particularly because they're out of sight, out of mind, I think, for a lot of people. But as I say, there is, I've been struck, and I've worked in quite a few government departments now, about quite what a job that is. It's changed massively, probably, over the last 20 years, but even over the last 10 years. And even if you take something like terrorism in prison, because of the TAC legislation that was introduced, we now see the prison population that is made up of terrorist offenders, just to give one example, has changed dramatically over the last 10, 15 years, with all the challenges that provides. So I think the prison service and the officers do an incredible job, both individually and collectively. And yes, I'm very focused on the investment to make sure we recruit more, we retain more, and we recognise the heroic job they do.
Baroness Checkenbarty wants to follow up.
Lord Chancellor, you touched earlier on your ambitions for a culture of free speech in our country. As a former government lawyer from 96 to 2001, I do have to ask you about the culture of free speech in your department. Now, at the turn of the year, we read that an internal survey suggested that a third of private office staff in your department answered that they felt that they had been bullied or harassed in the previous year. Now, I know you are currently under investigation, but as we've learnt today, you've got a great deal of responsibility in the interim. You are still in post. You've used the word humility, I think, 2 or 3 times. So I have to ask whether anything is currently being done in the department to improve staff morale and just to perhaps change the culture or just improve people's sense of self and worth and ability to do this vital work.
Thank you. And look, I'm not going to touch on anything which relates to the inquiry. I'm sure you would agree that would be improper of me. But let me say generally, both in previous departments and in the Ministry of Justice, I would say we're served by a terrific cohort of civil servants. By and large, the relationship is very effective with ministers across the board. I think that we've also got a very ambitious agenda in the way that I've described, and the overwhelming majority relish that. That's what civil servants, and like you, I was a former Foreign Office, a former government lawyer, so I appreciate the equities and the value of the civil service. I work very closely with Antonio Romeo, my permanent secretary. We've got all the processes in place, and we monitor in relation to bullying processes and procedures to make sure that folk who want to make a complaint can in the right way. It's important that that's there. And also I recognise that COVID across the board has been very difficult. It's been difficult for anyone working in HMPPS because of the impact on the prison regime of COVID. I think in terms of the courts, obviously, if you take jury trials, the social distancing rules had to be changed. That's created a backlog.
Chris, I understand that, but I'm talking specifically now about your Whitehall staff, your private office and close staff. And in the spirit of humility, regardless of the investigation, which will no doubt conclude, we all hope, I'm sure you hope, that concludes shortly. In the interim, in the spirit of humility, have you done anything different? Have you reflected and done anything different? Because it is a serious thing to be accused of. Have you done anything different to perhaps change the dynamic in the department close to you with your close staff?
Yes, so I think you're now trying to take me into the inquiry, which is improper and it's got nothing to do with free speech, and I'm going to leave it there.
I would like to be able to use what time we've got left to where there's a possibility of our taking the discussion further, if we can. Sorry to stop you, Jamie, but can I move to Baroness Archer, Molly?
Yes, Lord Chancellor, if I may ask a question which rather follows Lord Sandhurst's discussion with you, if I may. We now have a considerable body of evidence showing that community sentences are more effective in reducing reoffending than short-term prison sentences. And obviously we're not talking about serious violent offenders here, we're talking about short-term prison sentences. And if I can just mention a couple of examples. The 2015 Scottish Government study, which referred to a number of different studies, all of which came to the same conclusion that community sentences are more effective in reducing reoffending. And also a review commissioned by the Sentencing Council, which actually concluded that short-term prison sentences actually promote reoffending, so other solutions are welcomed. And I wonder if you can help me understand why the government continues to promote short-term prison sentences, bearing in mind that ever-growing body of evidence suggesting that's not really the right way.
Thank you, Baroness Meacher. I think actually the evidence is mixed, but I do take on board the evidence that you've cited. There are two elements to it. One, are community sentences getting more effective? I think things like community payback, electronic monitoring, have all been significant steps forward, both in rehabilitation terms. Think of community payback, visible community payback. I've been and seen in Birmingham and elsewhere the kind of work that's been done, for example, to clear up and clean up a community, and there are other things that are being done. I think when members of a community see offenders righting those wrongs and engage in restorative justice, I think it is quite a powerful thing. So both in terms of rehabilitation, but also public confidence, I think I agree with you. And as that evidence base for what works progresses, I think we'll use more of it. I mean, if you look at electronic monitoring and you look at community payback, we're doing it. We're absolutely driving that forward, and the more that can be effectively diverted from the prison population, the better. I do also think, though, as a result, the cohort and the quality, not just the quantity of those in prison, has shifted quite significantly over time. I think it is very difficult to get into prison. There's probably two areas of this that I would want to look at. But I think, by and large, you've got very serious offenders in prison, and that should be. The two areas where I think we need to do more, I think there's a cohort of mentally unwell individuals who trip up into prison. And if you look at the NHS, the forthcoming NHS bill, and the work I've been doing with Steve Barclay to end prison as a place of safety, and to ensure that NHS and community NHS workers take responsibility for those individuals, I think that is very important. The second cohort is, which I want to remove from prison as best I can, is the foreign national offender population, which is over 10%. Now, removing them, whether it's to Albania or other countries, where it's safe, and I think the top 5 cohorts by nationality of FNOs in the prison population in England and Wales are European. It just ought to be a no-brainer, but it is very fiddly. You need to either have a PTA in place, a prison transfer agreement, or you need to have the early release scheme operating, and that requires, of course, great cooperation with the Home Office, which we have, work very closely with the Home Secretary, but also the relationship with those countries involved. But certainly in relation to European countries, and perhaps with a more positive relationship with our European partners, may I say, as we resolve things like the Northern Ireland Protocol and turn the page on, if you like, the Brexit era, as we deliver it and take the advantages. I think there's also an opportunity with those bilateral relations to expedite removal of FNOs. I think aside from prison supply and capacity in the 20,000 prison places, if we could deal with that component of mentally unwell folk who trip up into prison, commit crimes, but if we had the NHS services in the community to prevent that from happening in the first place, and if we could remove more readily the FNO population, we would, we've got a programme of work to do both those things, but if we could deal with both of those problems comprehensively, it would substantially ease the numbers in prison.
Thank you for that reply, Lord Chancellor. I'm really pleased you mentioned restorative justice. It seems to me there's a lot of potential in there. You really can turn people around, or begin to.
Yes.
The other one I wanted to mention is that what comes out of all this evidence is that the value of these community centres is where they seek solutions to the underlying causes of criminal behaviour, which is, I think, what you were somewhat alluding to in terms of mental health.
Yes.
What proportion of prisoners either have mental health or addiction problems? So it seems that we're not too far away from each other in terms of really wanting far more focus on getting at those fundamental causes of criminal behaviour and dealing far more with people within the community in that way. Hopefully we'll reduce the numbers of victims, reduce the amount of reoffending, and make some progress. So
yes, and I think that's right. You could add others. I mean, homelessness, mental health. We've talked about drug addiction. I mean, alcohol addiction as well.
Sure.
Family breakdown, and all of those things. I would just gently make the point that since 2010, the reoffending rate overall has declined by 7 percentage points. If you think of the number of crimes and harm to the public that spares and saves, that is strong progress, but more to do.
But why is it government still promote short-term prison sentences rather than promoting what you've really been saying, which is the need to focus on
We're doing both. I don't look at this in a theological or a binary way. I accept all the arguments I'm not sure arguments, but the case for reinforcing the effectiveness of community sentences. But I do also think that there is a case for shorter-term sentences in some contexts. And I think it is very individual specific. And it's quite hard to get, I mean, it is quite hard to get a sentence of imprisonment these days unless you've done something both significant and serious and that involves or that involves a risk to the public.
You don't accept the Sentencing Council's conclusion that short-term prison sentences actually promote reoffending?
Look, I think if you can use the prison regime to deal with skills, addiction, employability, mental health issues, they can actually have a positive impact. We didn't talk about numeracy and literacy levels in prison. They are astonishingly low. So there is certainly more that we can do, but I don't think it's quite as binary as some suggest. And what we need to try and do is be absolutely robust in public protection. But again, for those that are able and willing to grasp the second chance, make sure that provision is there. I think that's the right approach.
Thank you. We will be, as a committee, pursuing these issues further over the next few months, so we'll be glad of further input from you, Lord Chancellor. I'm going to turn to the issue of the Lugano Convention and ask Lord Sandhurst, but can I explain first, we have on the line Baroness Shackleton, who wasn't sure whether she was going to be able to access a good enough connection. So after Lord Sandhurst has come in, I'm going to go to Baroness Shackleton. Lord Sandhurst.
Lord Chancellor, me again. As you know, the Convention provides for the recognition and enforcement of a wide range of civil and commercial judgments between all of the EU and EFTA states. So we're no longer part of that group. In April of 2020, the UK formally applied to accede. We're still waiting for a decision. The EFTA and non-EU states have said they're willing to support our application, as you know. Your predecessor, Sir Robert Buckland, told this committee in 2021 that the government believed that to accede to the convention would be the right outcome for consumers, citizens and businesses, not just here, but in the EU. At the moment, or historically as I understand it, the EU is playing hard to get on this. Is it still the government's wish to accede? That's the first thing. And if not, why not? But assuming it is, now that we have, we hope, the Northern Ireland agreement in process, isn't this the time now to make a real push for Lugano?
Thank you. I think it is an important area, and I looked at it as Brexit Secretary and as Justice Minister previously. The EU's position was in the way you described. I'm not going to say anything pejorative. I think it was part of political stubbornness. Lugano is a good example of the kind of win-win thing that whatever else we ought to continue doing. The government is still committed to it. And of course the EU decided, effectively it got delayed until after the TCA had been negotiated and concluded. But we will, I still think it is a good thing, and we will approach it in the right way. I'm reluctant to go running after the EU in the sense that there is always a price to pay. What I would do, though, is make the argument for win-win, and hopefully there is a new atmosphere that would allow that to end in a more propitious conclusion. Shall I just leave it there?
I'll leave the follow-up to Baroness Shackleton, who I think is bursting to answer.
No, I'm not quite bursting. Lord Chancellor, apologies for not being in the room with you, and thank you for coming. I'm fairly passionate about this because the area of law that I do benefits by cross-border reciprocation of the enforcement of financial judgments. And isn't there a case to be made to the EU? It's just as much in their interests for them to be looped up with us as it is for us to be looped up with them in Lugano.
Yes, I agree. It's win-win in the way I described. If you look at what's covered, I would have thought, and as a, given all the challenges that we've got, the commercial interest in doing this and trying to remove barriers to resolving disputes and dealing with cross-border disputes in particular, I think it's a no-brainer.
Thank you very much. So will you try extra hard?
Only because you asked so nicely.
Lord Chancellor, I don't think you need to be a groupie running after other states on this, but I think it seems to us that you have a very personal opportunity to talk to your counterparts in other states. And as you say, it's win-win. So no, it doesn't impugn our position to make the point direct to them.
No, absolutely. No, and I don't think we should be, we need to move beyond the debates of the past. I've actually got a good opportunity coming up. I'm hosting with my Dutch opposite number a meeting on Monday, which is about, I think, 30 to 40 justice ministers or attorney generals coming to support the ICC in relation to its work in Ukraine. It's quite a good opportunity in the margins. This is the kind of thing I'll raise.
Yeah, thank you.
They're not all European, I should add as well.
Just thank you very much. Of course, the real point is the deterrent point of having it in place stops people offending and breaching agreements. So it's just knowing it's there, but it's of real significant value.
Yes,
Thank you.
well articulated. I totally agree.
Thank you.
Thank you.
You talked, Lord Chancellor, at the beginning of this meeting about meeting victims' family, and how concerned you are about victims. Can I raise with you the appointment of the Victims Commissioner? In November, I think it was, you said to the Justice Committee in the Commons that you thought it was an incredibly important role, and that you expected to appoint to the post as soon as possible in the new year. Can you update us, given that there is much concern in the public domain about the position of victims at the moment, and rightly, and we've got the Victims Bill coming up. Can you update us on the appointment process?
Yes, of course. So, there's obviously a much wider victims agenda. I've talked about the quadrupling of funding for victims. We've got the Victims Bill coming forward. And of course, I have to say, when I meet the victims, I wouldn't say universally, and it's not for me to speak to them, but the number who want us to pursue things like parole reform to protect them and others who might face the kind of situations they faced is very striking. In terms of the Victims Commissioner role, obviously I've got to follow the process and do it in the proper way, but I can tell you that we expect to appoint a new commissioner by the end of the spring.
In parliamentary speak, spring could probably be anything up to the middle of the year. Have you shortlisted? Whereabouts are you in the process?
There are interviews ongoing. Yes, we've shortlisted. It will be more meteorological than, if you like, political spring.
Right. Thank you. Baroness Sanderson, Liz.
Thank you, Chair. Thank you, Lord Chancellor, for coming today. I have the last question, so I will be very quick. It is about the Independent Public Advocate, which we're very pleased to see here. I just have one question. So the consultation was in 2018, and I think you have said publicly that you sort of welcome the input of victims and survivors, and I should declare an interest as somebody who works with the Grenfell community still, as you have done in the past. It's just really to make sure that their voices will be heard in the shaping of this, because, and sort of with direct engagement, because if we are going to get this right, they are the ones that will give the greatest insight and input, and so it's just to make sure that that is part of the sort of strategy moving forward.
Thank you for all your work. As Housing Minister, I work very closely with Baroness Sanderson at a very difficult time with the victims of Grenfell. I would be very happy to meet them in person. I've written to them, as well as, for example, the Hillsborough families and victims groups and individuals from the Manchester bombings. We will, for the IPA, we are searching for a legislative vehicle. I hope to say more on that shortly. I'm very keen to do this sooner rather than later. And I want to make sure this is something that all victims groups, I suppose, existing but also prospectively, have got confidence in. And we'll be listening very carefully both to the views from, this is a cross-party issue for sure, both in the Commons but also in the other place. And I think what would be great is one of those rare things where there is a cross-party interest in doing this, and if we do it with sensitivity and care, I think we can get something we're all proud of.
Great, thank you. Thank you very much.
I think the sense from the Lords when the statement was debated was that this is a really good thing, and it shouldn't be spoiled just by trying to get a really good thing actually in place, when a little time and deliberation would help it be an even better thing. Yeah. That'd be a fair summary. Thank you. Now, we have a few minutes left, I think, before you need to go, Lord Chancellor, so let's use them as well as we can. Let me look round the committee and see if people would like to come in. I have a few questions that I'd like to follow up on, but not ahead of colleagues. Okay, well, can I go back to the question of tagging? Lord Chancellor, I'm sorry, this is going to be a little bit kind of bitty. You talked about the development of the technology and restrictions on individual freedoms. Are there any corresponding additional safeguards that we should be thinking about as the technology develops?
When you say safeguards, I mean do you mean safeguards for the offenders or for the public?
Well, I would see those all as part of one issue, actually.
Well, I think the big thing is the reliability of the technology. And as I said, the GPS tagging is much more reliable. And that as technology improves, confidence in it improves. It's not just about tagging. We now have alcohol abstinence orders backed up with the ability to monitor whether an offender, for example, has breached and is drinking in contravention of a licence condition or a community order. They are something like 97% compliant, and that shows you what good technology can do. It effectively has that deterrent effect, which is the elixir that I suspect Justice Secretaries, Home Secretaries are looking for. It is virtually full compliance. Imagine if we could do the same for some form of drug tagging. It would be extraordinary. It would be a real game changer. So as well as GPS, RF tagging, alcohol abstinence orders and the technology that's required to make those effective, we're also looking at the next generation. We're not there yet, but I just wanted to give you a sense of how we shouldn't rest on our laurels with the technology, and actually we should go further.
It's certainly, Chair, come a very long way in the 20 years that I've experienced it. We had problems when the technology could not distinguish between a living human being and an artificial limb, so people were actually able to take it off and make a nonsense of it. But if it has improved so much, why is it we're not using it back to the IPP on licence in a much more effective way, which would allow follow-up rather than return to prison? Follow-up in terms of remedial action on alcohol misuse, for instance.
I mean, it's a bit like mobile phones, Lord Blunkett, but the GPS tagging was very effective, but we've also, the cost of it has come down as the technology has been refined. So some of it is about the innovation and some of it is about the cost, given, as you rightly challenge, the desire to, when you've got a good product, do it more at scale.
There are all sorts of jokes that could be made about do a U-turn now, I guess, on this. But can I just check, is the new technology being used for all current tagging, or are some people on old technology?
Inevitably, we want to cover the whole range, but the GPS tagging is being used as much as possible, given the volumes that we can procure, given the cost, to focus on the most serious cases and the cases where they can add the most value.
Right, so it's a gradual changeover to a new system rather than everybody.
It depends on the offender, and it depends, for example, an offender where actually all you need to know is, are they at home? Yeah. RF tagging, I mean, there's been improvements in that, may still serve to do the job. But if it is a more granular set of restrictions on what an individual can do, and I gave some examples in my earlier evidence, then that's clearly ought to have a greater call on the GPS tags that we use.
Okay. To change the subject, not quite completely, but substantially, the NOJ has, I think, the second largest government estate, not just prisons, but courts and tribunals, for instance. Meeting the carbon neutrality objectives, I understand that the MOJ's delayed the publication of its strategy. The NAO, the annual report for 21-22 reported that of 8 commitments on a RAG rating basis, red, amber, green, 4 of the 8 were rated red, which means hasn't happened, not a lot of likelihood. 3 amber, well, sort of getting there. This is not a technical way of describing it, but it hasn't not happened. There's a risk that it won't, and only 1 as green. So what effort is the MOJ putting into this? It's obviously part of everybody's agenda now.
I totally agree, and we're entirely committed to the net zero 2050 target. Just to give you the headline, we've cut emissions by a third if you compare 2022 to a 2017-18 baseline. So I wouldn't accept a characterisation that didn't take into account that dramatic shift. The kinds of things we're doing are on energy efficiency, reducing emissions from heating and transport, increasing energy generation in the estate itself. Obviously, the estate is enormous if you include the prison estate and the courts estate, and there are some bits which are older than others, and it takes time to get around it all. But, I mean, just to give you a sense of, I mean, if you look at HMP Millsike, it's an all-electric prison. And that will reduce operational emissions by something like 70% compared to a prison like Fosse Way. In 2021-2022, we invested over 6 million in boiler efficiency devices. We've got £20 million from BAYS, or was BAYS, now DESNZ, to decarbonise our dirtier fossil fuel boilers. We're installing, I think we have installed over 600 electric vehicle charging points. So more to do for sure, but we are doing our bit, and I hope the initiatives, but also the headline reduction in emissions gives you that sense.
We're all, I think, aware of the one of the challenges that faces you is the state of the courts and tribunals, buildings, and how work is hampered there with buildings not in a position to be used because of their condition. And it does seem to me that one should be looking at dealing with physical condition and using the opportunities. I say this as an occupant of a building where similar problems arise, as we all are. But that would be an opportunity, wouldn't it, to actually to think about a bit more forward-looking, not just sticking bits together.
I totally agree, and of course I discuss it regularly with HMCTS and the judiciary, and of course the court conditions are more just, I mean, I think when people consider it, or lay persons consider it, they just think, well, you know, think of it in terms of the quality of the rooms, but of course has a big impact on judicial recruitment and retention. Probably as much as financial considerations. The feedback to me is that the conditions of the court estate, where they're good, can have a really positive impact. Where they're less good, then the reverse is true. So I am very focused on that, and it's always if and when we get an underspend, as well as the significant amounts we're investing in, if and when we get an underspend, it is one of the first things that we prioritise.
Okay, right. 3 minutes. Baroness Peshawar first, then Baroness Meacher.
Thank you. Mine is just a brief request, if I may.
Of course.
Because it will be very helpful if your office can send us some figures about the impact that the changes you introduced, from transfer to open prisons, what impact that's had on the numbers. That would be very useful. What was the situation before and after?
We'll provide that to the committee, and it's a perfectly reasonable question.
A very quick little one, just following up our earlier discussion, but in relation to courts. You very helpfully said if people with mental health problems could be dealt with by the NHS, great. Do you therefore support courts that divert people from the criminal justice system into treatment? Would that be something you'd really welcome?
Well, that's a matter for sentencing, and any Lord Chancellor knows very carefully to not impinge on those prerogatives. But actually, the truth is, if someone with a significant mental health challenge ends up in court because they haven't been dealt with properly, treated properly, then we've intervened too late. So I think I would have probably more emphasis, if I may put it like this, on the work I'm doing and my department's doing with DHSC. And if you look at the consultation papers and the proposals and the legislation, the time limit for referrals, the ending prison as a place of safety, and the preventative work is crucial. But no, I think it's a fair question. But I'm always careful not to comment on judicial sentencing or listing. That's a very sensitive one as well.
Thank you very much. Well, thank you very much, Lord Chancellor, for your time and what you've shared with us. I know that from the work that we have planned over the next few months, we will be coming back to you asking for your input to what we're doing. I'd like to take this opportunity, if I can, on behalf of the committee and including our staff, to say a very big thank you to your officials with whom the committee's staff deal. They're notably very helpful, not only in responding when questions are raised, but in alerting us to things which are coming down the path. And we appreciate that very much. We appreciate their taking the care to work in partnership, if I can put it that way.
Thank you very much. They'll appreciate that.
I'd be grateful if you could pass that back to
I certainly will.
Those
one very small point, Chair. It is the Ides of March. The last Lord Chancellor who came before us had gone by 3:30, so we wish you well.
I take moral support from wherever it comes, Lord Chancellor.
Thank you. That concludes the formal part of our meeting. Thank you very much.
It's two.
The proceeding has ended. The proceeding has ended. The proceeding has ended.